All right, so we're up to section 2, and I'm talking about treatment, and this is also a very interesting case. Let's see the first case. Oh, this is Labor Code section 3208.3. I went over this last time. This is really this is the code section that almost runs the whole workers' comp psychiatric system. You need an actual event of employment. Now, what does actual mean? Just the dictionary definition means real. Because there was a case years ago where a lady worked at Albertsons, and she thought the boss was trying to pick her up or hit on her, by the way he was looking at her, what he was saying, but she was almost a fantasy. It wasn't real, in other words. She filed a workers' comp claim, and 20 years ago, she collected, even though it was all in her head. It wasn't a delusion, but it was quasi, I would call it delusional. So the legislature got upset when there were enough complaints made from insurance companies. So now it has to be a real event of employment. You just can't think, oh, I didn't like the way somebody was looking at me. Well, maybe they had something in their eye. You really don't know what it was. Or it has to be a real thing that happened. So that's what actual events of employment means. Now, we went over this last time. Preponderance. In other words, over 51% plus of the work injury, not the overall disability, but the work injury has to be related to the job. As I defined last time, I found my Reyes case here. Okay. AOE, COE, which means arising out of or in the course of employment, remember? So that's the injury, though. That doesn't necessarily mean the overall disability. And the 6-month rule I'm going to talk about in a little while. You have to be working at a job for 6 months. Again, this is where psychiatry is the whipping boy. You can show up at work in California. I don't know, I'm not going to speak about other states. I don't really know. Because each state has their own workers' comp law. So that's 50 sets of laws. And then you have about another 10 federal sets. And then you got Washington, D.C. So there's a whole bunch of them. You have to be working, but you could show up at work on your very first day. Let's say it's here, you're parking at the county hospital parking lot, you step out of your car, step into a pothole, and break your ankle. That claim is compensable. You haven't even showed up at work yet. You haven't even punched in. In psychiatry, no. There's the 6-month rule. There's a couple exceptions which we'll discuss. Then there used to be a whole bunch of people. There were actually workers' comp mills, which have now been shut down, where people would file claims because they were let go from work. It's called a post-termination claim. So there's all sorts of rules on that. In other words, your boss calls you in, says, sorry, Joe, factory's closing. So 100 people get let go. And they all run in and get attorneys, and they file claims for depression, adjustment disorder, whatever, and they collect workers' comp. When that runs out, then they collect money from the state. Then they collect unemployment. So that is significantly limited. Then what about the personnel actions?
Can you collect for psychiatry? You cannot anymore.
Not if your only reaction is that you were terminated and you're upset because the factory closed, or you're upset because your boss called you in and they said, you've been late, you've been taking too long with your lunches and your breaks, or the quality of your work hasn't been good, the quantity hasn't been up to par, we're going to let you go. That's a personnel action. That's a very difficult claim. And if a worker goes into an attorney and that's his beef, that's his cause of injury, many attorneys are going to turn it down. They're going to say that's very hard. Is it possible that then sometimes but you could go outside workers' comp and sue for wrongful termination. And maybe you'll win a couple $1 million on that. Usually you won't. It's a tough thing to win if they can document. And the standard is lawful, in good faith, and non-discriminatory. If they can show that the personnel actions were lawful, in good faith, it sort of means true, and then non-discriminatory means they're not picking on women or males or females or certain races. That's a tough one to beat as well. But I'm going to go through a few of those because all these are cases. Now this is first of all, treatment. Now here's an interesting case in workers' comp. The reason it's interesting is, as I said before, workers' comp is not known to be exciting per se. But this case here, the Braewood case, Braewood, that made the first page of the LA Times. Now, how often does a workers' compensation case make the first page of the LA Times, assuming, Trifco, that people are reading the LA Times? The story there was an overweight man who asked the insurance company for treatment for his overweight. And they said, well, we hired you when you were heavy. When we hired you, it's not our job that you lose weight. Well, actually, as I discussed last time, if your weight problem must be treated, as I say there, must be treated in order to treat the industrial injury, let's say that your back, maybe you had a heart attack, maybe you have some other injury in your knees. So it actually is the responsibility. But so the insurance company in that case, and I'd have to look to see which company it is, I don't really know, they declined. They turned him down. And they said, we are not helping you. It's the insurance company? Well, I'm not sure which one it is, actually. It might be Insurance Company North America. Not sure. Anyway, it doesn't matter who it is. So whoever the insurance company was, and he worked at Braywood Convalescent Hospital. So he had a claim now for his back. I think it was physical condition, his back. And he said, now it's your duty to help me lose weight. And they basically said, screw you, it's not our responsibility. So guess where he goes? He goes to Duke University. He leaves somewhere on the West Coast. He flies to Durham, North Carolina, and enters into the live-in #1 obesity clinic in the world. That's what it says in the case. And he was supervised there. He loses weight, and now he makes a claim against the insurance company because they didn't want to pay the hospital. And guess what? This goes all the way to the California Supreme Court, and they said, this is what they basically said, that the employer must pay all of the bills from Duke University to help this gentleman lose not Mr. Braywood. What was his name? I'm not sure of his name. Not sure of his name right now. Anyway, you must provide treatment to him, and it was because this is an interesting case because he had doctor's letters saying that he needs to go to lose weight. Now, did they recommend that he go to Duke on the East Coast? No, but he went there because they said no. So once they say no, a worker can go anywhere he wants. And if he gets them to wait for their money and then you go to court and win, that's what happened. It didn't really matter where it was. And they had to pay, the insurance company had to pay the whole bill. And believe it or not, this case, as unexciting as it is, it went to the California Supreme Court, as you can see from the date, 1983. That's still good law in this state. By the way, just as an aside, do you think it's fair that the employer gets stuck with taking care of the pre-existing problems of a worker?
I don't think it's fair.
Okay, that's one opinion. You think it's fair?
No, I mean, it's hard to say because what happened is he got his back hurt.
Yeah, he had a bad back. Yeah.
And then in order to treat the back,
Yeah.
they had to treat the underlying
Pre-existing problem of overweight. You think?
Yeah, I mean, it doesn't seem fair. But on the other hand, I could see a situation where an employer gets an injury and then has some other pre-existing condition and does happen in the
Employee gets an injury.
Right, and the employer should
But
pay.
let's say this happens. Let's say you're hired with a little bit of hypertension, and I'm not arguing for or against it, but this is the reasoning they use. Where you're hired with some hypertension, 150 over 95 or whatever it may be, and then you tear your knee up, and then they do a pre-op physical. They say, wait a minute, this man's hypertensive. We can't operate. We got to fix his knee, and he wouldn't even be in my office now if he hadn't got hurt at work. That's the theory. If he hadn't got hurt at work, there wouldn't be any blood pressure problem to treat because nobody would even know about it. But now we can't treat his work injury. That's where it comes, supposedly it's fair.
But if he had a documented case, like he was hypertensive before he began work and he was getting treatment for his hypertension, and then he did what you said and hurt himself.
Oh, okay, then he hurts his knee. Well, okay, if he's getting treatment, that's a different issue, and that should continue.
But what you're saying is that in that case, it
Yeah.
actually prevents his surgery from happening.
That's the whole point.
That's the issue. But
Yeah,
in
that's
this case, this guy has back injury.
Yeah.
Does it seem like his obesity is like preventing him from getting any procedure or anything? But of course, like if you're fat, your back's gonna hurt more. I mean, that's just a known fact.
Well, yeah, that's...
Yes, doctor, that's going to happen.
No, I'm not gonna, you're not, you mean another doctor in the room. Anyway, it says that it's imperative applicant lose weight. Applicant means the person, that's the like plaintiff, that's the workers' comp word of art for plaintiff, to lose weight in order to obtain relief from his industrial injury. So I'm not sure what relief they were looking at. I think they were going to do surgery on this gentleman.
I mean, that's a different story. If like they say, you need surgery, or we can't do surgery on you because there's too much fat, well then that makes more sense, because then you do need, I mean, the surgery, you know, needs to happen because that was a work-related injury. But
Yeah, here they're not even going to do surgery, I don't think. I think they're really just saying he needs to lose weight to get more, to benefit more from physical therapy, and that's more gets into the thing where you might be so-called trying to take advantage of the employer.
I'm actually surprised they didn't like find out how much it would have costed him to do the program here and then just reimburse that part.
That's an excellent question too, but I think once the insurance company said no and they denied his claim, they were kind of stuck, and then the worker, then the defense that they brought up was that it was unreasonable because he went too far away. And the employer must present evidence, I'm just reading from the case, demonstrating the availability of a similar program. And I guess they didn't do it. I don't think they really had anything to do with it because they didn't think they had a chance of losing. And lo and behold, they lost. And they ended up on the front page of the LA Times. And let's see how the court was. Let me see this. We have 7 on the California Supreme Court, right? So we had Rose Bird, who's pretty famous. She wrote it, I think. 1, 2, 3, 4, 5, 6. 6-1. It's pretty unanimous. Excuse me, more than unanimous. 6-1. And that has never been attacked as law since 1983. That's the California Supreme Court, and courts don't like to reverse themselves. So that's good law still. Gets interesting issues regarding what about somebody who was taking Prozac and Paxil for 20, or Paxil and Wellbutrin for 20 years when they get hired, and now they're more depressed. What do? You're not supposedly in this state supposed to apportion treatment. But they already were taking Paxil for 20 years, and now they're more depressed. So the employer pays the increase, you think? Is that fair? Now they're more depressed because their back screwed up and they lost his job, whatever it might have been, driving a bus or doing construction.
So you're saying now the law is that doesn't matter, right? Because that's compensable.
Well, no, that gets confusing, the compensable consequence. Let's just leave that. Let's pretend I was here December 31st before the new law. You can argue that the employer should only be responsible for the increased dose of medicine or the increased number of visits. But you're not supposed to apportion it either, and that doesn't make sense. That's, as we know, we're all in this program. I finished it, and you're all in the program. Law and medicine don't always mix too well, and it's one of those areas where you're not supposed to break down the treatment, but sometimes you have to. But this Braidwood case is very interesting, as I say, because what's he going to do? Sure, they could have found a lot of programs, but the point is they didn't do it. They just basically closed the book, said, screw you, we got nothing to do with you losing the weight, you were fat when we hired you. And he fought it all the way, and they got some sympathetic judges, and they went to the California Supreme Court, and they won. Or he won, excuse me. All right, let's go to the next case. This is the 6-month rule. This is the Garcia case. This is an interesting case, too. Again, they're tough on psychiatry with a lot of these cases. We all chose our field to go into, but we also know it's a lot more subjective than others, and it's obviously more, I'll read a couple seconds of this case, which are interesting. Anyway, they say now, if the worker is on the job for less than 6 months, they can only file a psychiatric claim for such very obvious stressful things as a gas main explosion or a crime of violence. In other words, you can't say, oh, I was a substitute teacher in Compton and the kids were yelling at me and screaming, and you file after 30 days a workers' comp stress case. Very, very difficult. Very, very difficult, and this is the wording they give for that. They say, it's interestingly enough, we talked about, it says, if he's worked over 6 months, this is page 3 of the case, and you'll all be able to get the case on the computer that you have. They say they want the worker to have an objectively, I don't think that'll be up there in the PowerPoint, an objectively verifiable component and less likely to be fraudulent. It seems that if you study much of the law, all courts are concerned that psychiatry is much more prone to being fraudulent claims and much more prone to dishonesty on the part of the injured party, whether it's plaintiff or workers' comp applicant. So that's the standard now. So it has to be a sudden and extraordinary event of employment. Otherwise, you're out of luck. You have to be there if you're there less than 6 months. I mean the worker. If the worker is there less than 6 months, the thing that injured them must be sudden and extraordinary. Now, how is sudden and extraordinary defined? Well, of course, sudden means quick, but extraordinary lends itself to, it really has to be defined as out of the ordinary, really. And they're using examples like a gas main explosion and, let's say, a crime of violence. Falling off a ladder? No, not really. Not if your job is climbing up ladders every day to pick fruit off of trees or going up on a roof. But then if you rarely go up on a ladder and then fall down and get hurt, that is considered extraordinary. So it has to be on a case-by-case basis, really. But again, that's another, as it says down there, uncommon, unusual, or unexpected. So it can be very serious. It can be, drive a truck and you get in a bad accident on the freeway and you get really very, very badly injured. But every slip and fall is going to be sudden, but they're not going to be, very few of them are going to be extraordinary. And I said they give specific examples: gas main explosion, bank tellers robbed. So that's the Garcia case, which is still good law, and I think I did the Court of Appeals as well. Now, remember I said before about personnel actions? If the employer could prove that the personnel action was lawful, I actually had to prove it. If it was lawful, in good faith, and non-discriminatory, the worker was out of luck. However, there was this interesting lady named Rosemary Verga, V-E-R-G-A. I saw somebody just like that. I testified a year ago. I said, your client was I think she was Rosemary Verga's twin sister. I think I said that under oath. What she did was, she was basically a troublemaker. And it says in the court, she brought upon herself the disdain of her co-workers because she was a difficult person to get along with. She was impolite, unpleasant, and co-workers never knew when she might get upset. So therefore, when she acted that way, and then the co-workers gave her some of her medicine, so to speak, then she filed a claim. Old Rosemary did. And the court said, no, wait a minute. She caused the stress for herself, and these were the words: rude, inflexible, easily upset, and demeaning towards other employees. So, as they say right there, impolite, unpleasant, rude, demeaning, and inflexible. Now, it used to be if you were that way and other people cursed you out back, you could actually file a workers' comp case. You, again, the worker could file it and win. Now, it's gotten, again, harder because they've narrowed the area, and it was not considered an event of employment. If you cause the trouble, other people get back at you, again, you're out of luck. You can see how you notice that things getting narrower and narrower, where the 6-month rule, if you cause your own trouble by being unpleasant, rude, they have to go out and get evidence. They have to go out, they being the employer, has to get witnesses. But if you spend enough time with somebody, you can, they'll probably be on their best behavior when they come in to see you. But, by the way, just as an aside, what do you think is an adequate time for a psychiatric exam? Shaylin, right? Mm-hmm. What do you, and let's say a workers' comp, let's say a 30-year-old person. So you're going to have to explore a little family background, what happened at work. How much time do you think you need?
Probably a few hours.
A few hours. Agree? Yeah, it takes a long time to get into it. So But what if somebody's kind of passive aggressive and not real cooperative, and can they contain it for a few hours, you think? I know it's a case by case basis, but
Probably not for a few hours.
yeah, probably not. Yeah, the longer you keep them there, yeah, the harder, and they usually can hold themselves together for a little while. But if
Unless
they're
they
real,
know to expect that.
what?
I said unless they know to expect that, and then they can prepare for it. I think what starts to happen is when people aren't expecting it, then their real colors start to come out.
Yeah, well, a lot of that's true. It's hard though but we got a tough job in our position because we have to say whether somebody can tolerate a job mentally, emotionally, for 8 hours a day, 5 days a week. Well, you're not going to be seeing anybody 8 hours a day, 5 days a week. Sometimes it's hard to make the analogy into that. But I think it is kind of hard. And then that's why they send out large medical files, because you want to see how they got along with other doctors. And the other doctors will comment sometimes, they were disruptive in my waiting room, they insulted my secretary, my nurses, blah, blah, blah. Plus how they act with you. But a lot of times, especially when, as I told you, most of the time I'm an AME, when they have lawyers, of course, they are spoken to by their attorney. This guy's got a lot of power in your case. Don't upset him. Don't get him angry. Be polite. Don't play games with them. And you know when they've been talked to by their attorney. After a while you can figure it out. And some of them are bright and they know anyway. But that's Rosemary Verga, and I think most people would agree that she probably shouldn't get any compensation or treatment because she caused the trouble herself, right? There's a couple other exceptions too, because people have argued against that case actually, and let's see how far to go. He went to the Court of Appeals, and it was never overturned, so that's a statewide law too. They say, well, but it's turning workers' comp into a fault system when it's supposed to be no fault. But there are some areas where it could be the worker's fault and he wouldn't collect anything, right? If he's intoxicated or he's fooling around, he's running around in here playing touch football in the hallway or something. If somebody notices how you got hurt, you shouldn't have a claim. You're supposed to be playing football down here. So certain things, they call it horseplay. You don't qualify intoxication. All right, so let's move over to the next one. I'm glad I don't work with Rosemary. Now, this is a case that we all deal with, unfortunately, suicide. And this also was a Court of Appeals case. The Burnite case, B-U-R-N-I-G-H-T. And the interesting thing with that case is, because in workers' comp, if it's a self-inflicted injury, it's not compensable. So therefore, let's say the person overdoses. So that's self-inflicted, right? So it shouldn't be compensable, except if it's the worker must show it's an irresistible impulse. And that's a quote right out of the Burnite case. If the worker thinks suicide is the only way out, it is compensable. Now you're going to say, well, wait a minute. The worker's dead. How am I going to know it's hard to do. How am I going to know what he was thinking? Well, you've got to get information. You've got to get medical records. You've got to sometimes interview the family. Are they going to be biased or prejudiced? Of course they are. But you just have to, that's what they say. That's what the law is. You have to do as good a job as you can. If you can't do it, sometimes it's okay. Sometimes you say, I can't do it. It could be this, it could be that, but it's too hard to figure out. It's sort of like, have you ever had to do testamentary capacity? Somebody writes a will, and now they're dead, and now the will is being contested and trying to say they were competent or incompetent when they wrote their will. How would you do it? Person's not alive anymore.
Guess you would need to find out what their state of mind was like when they wrote the will.
Right. And you get that from medical records, family, friends, doctors. When I took wills and trust in law school, I remember asking the teacher, well, why don't you cut down on a lot of this litigation, trying to throw out wills by videotaping or audio taping the wills? And he says, oh, you forgot, John. We're lawyers. We like lawsuits. We like to sue. We don't want to do that. So they create some confusion sometimes by not doing that stuff. But that's the law on suicide. It has to be so-called irresistible impulse, which of course, from criminal law used to be in some states the law, right? I've seen, though, interestingly enough, that some doctors and judges not understand, and they just say, if you got a bad back, he's depressed. If he didn't have a bad back, he wouldn't be depressed, and then he wouldn't have committed suicide. And I've seen that be an acceptable case. But I think this is really the law, and this is the better way that should be dealt with. So that went back to the judge, and I think I gave another suicide case there that confirmed that, the Donovan case. It confirmed the Burnite. So that's really interesting. That Burnite, what it stands for is that suicide, in order to be a workers' comp death, must be, it's been around for 53 years. Now you're probably saying, and I don't know, what happens if you are killed at work? Because does anybody pay any money to anybody? Like your employer's insurance company? Who would collect? This is more legal than a medical, but I'm just, yeah, family. Anybody dependent on you.
But wouldn't your family need to file?
Had need to file.
Yeah.
Anybody dependent on you, which would be, but I think it's a lump sum of around $300,000, maybe $20,000 to bury you, and then if there's some minor children that are under 18, they can get a few hundred a week till they're 18. So it could be a lot of money, is the best way to put it, be a lot of money. But it's dependence. And if there's no estate whatsoever and you have no relatives, then yeah, the state gets the money. That's where it goes. But anyway, they're sort of like, they don't want to let the insurance companies off the hook if there's a suicide. Okay. So, but that is hard to do. There's no question that's hard. You got to get records. You'd hope the person's seeing a psychiatrist. You'd hope there's some records. You'd hope there's some statements like, Doc, I can't stand it. Sometimes you'll have a tape recording. I've listened to tape recordings of guys just before they committed suicide, when he's gone down the beach with a shotgun. And I remember listening to it, and he shot himself in the heart and killed himself. But I listened to the tape, and I say, well, this guy really, and that's basically what he said. It's the only way out. I can't stand it anymore. I don't know what to do. And that, I think I wrote a report that guy.
So him saying that it was because of his job, he kept saying he didn't know what to do.
Well, they usually won't say job. They'll say because of my back, putting me out of work.
But if somebody was under a lot of stress and pressure at work, and then because of the job, they killed themselves because the stress was just so much.
I don't know that I've ever seen any death cases with that as the history. Does it seem possible? You'd think, well, the guy's away from his job, it shouldn't be as bad, but you could develop a major depression, even with psychosis, right, to an outside stress, and now you're away from the stress. But I always say there's guys walking around the VA who've been there for 40 years who can't function. I'm not trying to compare job to combat, but, Now, let's see. This here is an interesting, this, again, like I told you, every part of the law, which is, it's probably a couple hundred pages that took effect a week ago, is going to be litigated. And this was a little part here, and actually a little part called Lockheed Martin. That was the employer. And the worker, this pointed out that you needed, an injured worker needed to have, this talks about compensable consequence, which may have disappeared a week ago. That said, this case held that the work injury had to be over 50% responsible for the present injury, and present psychiatric injury. And then they talked about, and they did talk about interesting things here. It's interesting reading how the legislature, how the courts get to their opinion, and this gets back to the resident doing these exams. The legislature, the undeniable fact that the legislature is aiming primarily at phony stress claims. The word phony, fraud, it keeps coming up. Doesn't mean that we're phony or we're frauds, but then it says especially filed by disgruntled, short-term former employees. So this is not the 6-month rule, though, but it said the physical effect must be over half. And how do you put numbers on it? Well, that's always hard to do. course. But in other words, more than just a little bit. But over half, if you can come up with that opinion, and you're supposed to give your reasons why, and as much as you can. And this basically said, that was my phone, I got to turn that off. Anyway, this basically said it's got to be over the stress due to the physical injury has to be over 50% responsible for your psychiatric injury, or you don't have a claim. Now that would come up with, what if the same day you hurt your back, you found out your wife was leaving you, husband was leaving you, child developed some was in a serious accident, loved one died, and it all happens together. Yeah, you'll file a workers' comp claim, but you got to separate, as a doctor, you have to separate one out from the other. And is it hard to do? Yes, it is. It is hard to do. But that's what Lockheed Martin case stands for. Again, let's see if this went to Court of Appeals. Yes, it did. Court of Appeals, like I told you before, any Court of Appeals case that the Supreme Court declines to hear becomes statewide law. It's the same as a Supreme Court decision. So that's Lockheed Martin. There's a Lockheed airplane. Let's see what we got next. We got a few more minutes. I know you got to get out of here soon. The Escobedo case, and I discussed this at length last time, and this is the one thing probably that gets more cases reversed than any other issue in workers' comp. Reversed by who? Well, the Court of Appeals or the commissioners in San Francisco. The difference between causation and apportionment. Causation is the injury, the present injury. Apportionment is your overall permanent disability. And it's interesting that the legislature didn't even know what they were doing when they wrote the new law. They tried to get rid of, they tried to allow you to blame some of the condition on pathology. But this case, the Escobedo case, holds that only if it results in disability. Only if this pre-existing pathology results in disability. And they also, in that case, which is important, they define, as I did last time, substantial evidence. Means reasonable medical probability. So when you write reports here, you have to give your reasons for it, right? That's what that means. You have to give your reasons, and they have to make sense. If you give your reasons and they make sense, and they make sense to a non-medical person, right? They make sense to a judge or an attorney, then they're probably of substantial evidence. So that's what the Escobedo case holds. That was a lady who, Marlene Escobedo, she worked at Marshall's. So we know who that is. I can't understand, well, I guess it depends who's appealing it. Sometimes cases are named after the employer, sometimes for the injured worker. Right here we got Lockheed Martin, which is the employer. Here we have the worker's name. Now the next case, let's see what that is. Benson case. That was recently, and eventually that'll not be that important, but the Benson case has to do with this. Let's say Liberty Mutual was your insurance company to 2010, and after 2010 it became Argonaut. So, and the person now has two injuries. They had one before 2010 and one after 2010. So each insurance company is going to blame the other insurance company. Oh no, he's supposed to pay it. Oh no, he's supposed to pay it. So they're going to look to you. That's the Benson case, Diane Benson. That was also an appellate case. And the doctor has to differentiate between the attorneys. And I say the two. If there's two or more, if there's just two, it's not as difficult. What if there's 5 or 6? Well, that becomes more important for the orthopedist. There's usually not 5 or 6 psychiatric injuries, but there could be 5 or 6 orthopedic. And sometimes it's difficult. It's not just. Oh, I got 20 minutes left, and it's 4:46. I got enough time to finish. So it's easy sometimes to say, well, she's depressed because of her back, and whatever the orthopedic surgeon says, I'll follow. Sometimes that makes sense. Sometimes it doesn't. That's the Benson case. And I have this little clip here. This went. Oh, wow! I didn't even realize this went to the Supreme Court. May of '07, this whole issue of apportionment. Apportionment is extremely complicated. It's basically trying to blame you're trying to blame something for the person getting to be the way they are, their overall disability. Okay, let's see now. Did any of you know that workers' comp was this complicated? Yeah, and it's not simple. I mean, and I didn't learn this in law school because they don't teach it in law school. I had to just pick it up. Now we talked about GAF. What do you think? Well, you weren't here last time. What do you think of GAF? Global Assessment of Function.
I don't think it's,
Too accurate, or?
no, not at all.
I usually say that's to justify a hospitalization, or for like clinics or Kaiser or something. Mm-hmm. What if something doesn't fit within GAF, which we have to use in California workers' comp because there's no numbers. We need numbers, right? AMA Guides doesn't have numbers for psych. What do you do? Because both of you ladies said you use GAF. What if there's something that's not GAF? What somebody's has agoraphobia, can't leave their house? It doesn't fit onto the GAF, does it?
I think anytime we give anybody a diagnosis, we just do the 5 axes, and that's the only time I even consider the GA. I don't consider it for anything else.
Oh, you don't? Okay.
That's just because it's part of our...
Right. So anyway, the Almaraz Guzman case said, well, AMA Guides, by the way, are very conservative, and they tend to be insurance-type opinions, insurance-type doctors. And they said, well, you can go outside the AMA Guides, but you have to stay within the 4 corners of it, which means the book, right? The book up on your shelf there. Where is the AMA Guides book? It's over the green book there. And I found one section that allows you to discuss some things outside the GAF, which is still within the guides. And I talk on page 362. It talks about bank tellers who were robbed. Back to that again. Or a worker who did not get along with the boss. And I don't know how many points disability to give for that. It used to be 10 or 20, 15. Now it's not known really. Because it's kind of complicated, but there's no definite numbers on that. But that just allows you to step outside and add things to the GAF. You could say, well, in addition to having a 60, which is top of moderate, or 55 or something like that, they can't work around disruptive students, and they can't work for Boss Jones. There's nowhere in the GAF for that, but workers' comp, you have to allow for that stuff. So I just add that into certain stress restrictions, as far as my opinion is concerned. That's what I do. Am I always right? No, some attorney's going to be upset with it. That's just the way it is. This is an interesting case here, LaBeouf. I think we're just about almost finished. LaBeouf, that's how you pronounce it. That's another Supreme Court case. To me, it's rather shocking how many of these cases go to the Supreme Court, because the Supreme Court does not like workers' comp. They, like most people, see as boring. But here's a case that went to the... No, this actually did not go to the Supreme Court. I think they again declined to hear it, which makes it state law. Another 83 case. No, it was the Supreme Court. I go back to that. It was, again, Roseburg. 1, 2, 3, 4, 5, 6. 7 out of 7. LaBeouf said this, basically, and that's why I have my numbers up there. Let's say the person has a 90%, through the complicated rating, however you come up with the ratings, and it is complicated, 90%. He's got a 30% orthopedic by virtue of his neck and back problems. He's got a 30% internal by, let's say, the heart, cardiac, blood pressure, and then he's got, let's say, mild to moderate, slight to moderate depression. So he doesn't have 100% disability. But then the worker, and that's what LaBeouf was, he went out to vocational rehab. Vocational rehab is to train him for a job. And this fellow, LaBeouf, he drove a bus up in Oakland. And the vocational counselor said, well, I know he's not 100% according to the rating. Okay. I'm not sure what I do here. I'll say, okay. I was not hooked up. Anyway, I think we're just about done. So But the vocational counselor said, this guy can't sit too long with his bad neck and his back. He gets stressed out because of his blood pressure going up in his heart, and he's depressed and is not real energetic. So even though his disability may not be 100, there's nothing he can do in the open labor. There's nothing he can do. So 30 plus 30 plus 30 equals only 90, but we'll give him 100%, and that's what the LaBeouf case said. He didn't total up to 100. It doesn't have to be 30, 30, 30. They're not magic numbers. But it had to be short of 100. And they said, once we test him to see what he can do, again, assuming he's trying and putting forth good effort, if there's nothing he can do, he's 100% totally disabled. Now, Trifco, I don't know what I do here. I just go like this? Wow, okay. So that's the LaBeouf case. Another case that went to the Supreme Court. So we've got a few here that went to the Supreme Court, right? LaBeouf, Braywood, Vinson, this Brody and these other cases. A lot of appeals cases went to the Supreme Court. So the state, and there is actually a certification in workers' comp specialty that, let me look at this. Yeah, I forgot. Fine. This talks about how, because somebody, remember I talked about falling off a ladder? A guy who was picking fruit, avocados, he fell 24 feet off a ladder. It wasn't extraordinary. Because that's what happens to guys who climb ladders. So that's what the court said with that one. And let's see, that's LaBeouf. And this is a post-termination claim. That's another it's almost like a personnel action. But it's very tough if the boss calls you in and says the factory's closing. Everybody's let go. How can you prove discrimination? Everybody's let go, and you're out of work. In today's economy, you can't find a job. Can you file a psych case for depression? Probably not. It's going to be tough. You can file it. Are you going to be successful? Probably not. But here are the 4 exceptions. Sudden extraordinary event, we've been through that. Prior notice of injury, you tell your boss you've been hurt. He fills out the necessary paperwork. Pre-termination treatment, so you have to have treatment and a record of it somewhere of psyche. It could be Xanax or Prozac, or they give you Ambien for sleep, but something mentioning you've got a job problem. And the last thing is, if there's been a finding of racial or sexual harassment by any trier of fact in the state, that would be an exception to that too, before you've been terminated. But once you've been terminated from a job, it's real tough to file a claim at that point for psych. Again, ortho, feel free. Just like you can file a claim the first minute of the job, you can file it after you get laid off. I think that's all I have. And how are we doing for time? What time do you have? 5. So if anybody wants to come out to my office, I'd welcome it, and it wouldn't be a problem, and you wouldn't get dragged into litigation. Some of these attorneys are a little bit insecure, and they might think, oh, it's 2-on-1, 2 against me. If I was in your position, I would have done it and would have found it interesting. I never did it. I never had the opportunity to do it. But if anybody wants to do it, you're welcome. I'd let you read the report before so you see what's going on. They wouldn't object. Any questions? We're just about out of time. Is anybody interested in going into workers' comp? And if you had asked me when I was here, I would have said no. But I just worked my way into it gradually. You?
Yeah, I'm willing
Stephen?
to try it out, see if I like it.
Yeah, let's see what happens. Attorneys love psychological tests. I haven't talked much about that. I have my own agreements. I get them to try to see my point of view. But I don't think there's a lot of value in the testing, but there's a lot of testing going on. So that's how I can be located right there. I gave my card to a couple people. Bruce could get you.
Thank you.
And thank you. And I hope it wasn't too, a little bit rushed, but there's no more questions, nothing anybody else wants to say, so
Not yet.
I'll get out of it.
If there's something, we'll email you.
Oh, yeah, well, yeah, you got my cards from last time, right? Yeah, sure, so.
Thank you.
Thank you.
Thank you. Do you have any more? I know Dr. Jax was in. Anybody else coming in?
There's a list of people